open it and you'll be able to get in.
Why don't we do this just to make it really simple? If you want to go back to your screen, and I'll stop sharing, and we can just take it from there. I don't want to cause too much.
I got you. No
too
problem.
Much craziness here.
So the first slide here, and we'll be ready to rock.
Okay, perfect. So we can go back to slide 6, I guess, and then we'll get started. So while Ryan's doing that with raising a lot of questions, let me do this. Let me first tell you a little bit about myself, so you know who's speaking here. You know about a little bit about our law firm, so you understand who's presenting today. So again, I'm Jaron Kelly. I'm one of the partners at Kelly and Grant. We are a full-service real estate law firm. We're located in Boca Raton, our office. We're sort of I'd like to say a medium-sized law firm. We have 4 attorneys and 16 paralegals. So we're big enough that we handle all areas and aspects of real estate law, but also small enough that you can always get in touch with an attorney. We're just a phone call or an email away. We love giving extra attention to all of our clients. And we do practice in a number of different areas of real estate law that includes a large volume of title and closing work, residential and commercial closings. We do all types of real estate litigation, disputes, escrow deposit disputes, security deposit disputes, breach of contract, quiet title, things like that. And then we also handle association law. And then the 4th large area of our practice, which is what I'm here for today, is our landlord tenant practice. We're filing probably at least about 300 evictions a month. That number has actually gone up exponentially, as we all know, due to the issues with the economy here recently. But we filed about 20,000 evictions in the last 7 to 8 years. So I say that because we have experience filing evictions in all counties. We serve all 67 counties in Florida, and we have a heavy presence here in South Florida, Miami-Dade, Broward, and Palm Beach County, of course, but other counties as well. So that's a little bit of background about us. So let's get started here with the actual content. You've been hearing probably a lot, seen a lot of emails, read some articles about the governor's moratorium, the federal moratoriums, the CARES Act, the new CDC moratorium that's come about on Monday, which is the big new piece of legislation, or really not legislation, sorry. Technically, it's an order from the CDC, from the executive branch of the government, and that's caused a lot of confusion. And that confusion is still being worked out. The attorneys in the industry, we put our heads together, we share knowledge and opinions with each other, and then we move forward with some of that, some of those opinions as best we can, and then we see how the courts and the judges rule on these different cases that we have. So I'll get into the details in a second, but we understand that we're getting a lot of questions from our clients that we do evictions for regularly. We serve small mom and pop clients that have 1 or 2 properties, all the way up to, we have large hedge funds that have thousands of properties in Florida, and large apartment complexes that have hundreds or thousands of properties. So we handle evictions for folks of all sizes, and we're getting a lot of questions, especially about this new CDC guidance or moratorium that came out on Monday evening. Some of these questions are, for example, what types of situations can landlords evict for if they can't file evictions for non-payment, which raises another question: can you file evictions for non-payment? Which the answer is sort of, maybe, possibly, but we'll get into that. How do these pieces of legislation affect each other? We'll get into that as well. Should landlords serve 3-day notices during this time frame? The 3-day notice being the notice that's the prerequisite for a non-payment eviction. Can landlords charge late fees and other types of fees? How are county court and sheriff moratoriums affecting the eviction process? When will this process clear up? All of these questions and more will be answered as I move forward. If they aren't, then you can go ahead towards the end of the presentation and you can type your questions into the Q&A section. I'll be here for a while, for as long as Ryan wants me to hang around, and he can hang around, and we'll answer some of those questions that you pose. But for the next 20 minutes or so, I'm going to start the presentation, and we'll roll through some of these different moratoriums and how they affect the eviction process. So let's
guys, like Jaron said, put your questions for us in the Q&A, those that are just joining us. If you put your questions in the chat, it's really hard for us to get to them. So just put all your questions in the Q&A. We'll come back to any questions that we have. And Jaron, maybe halfway through, if we've got a lot of questions, we could start then. But I want, he needs to get through some information, guys, because some of these questions you're asking, he's probably going to be covering them.
Correct. So probably better to put your questions in towards the end, because I probably will cover most of these. So here's an example. For example, the governor's moratorium extension. You'll see just an example of what an executive order looks like from the governor. This was the most recent one that was actually issued on August 31st, extending the eviction moratorium through October 1st. I will get into the details of that because this moratorium is not all encompassing. It's actually very specific for certain types of cases. Okay, so let's move on. The first thing that I want to do is I want to talk about the typical eviction process. There's many of you on this webinar that have never gone through an eviction process. You don't know exactly how it works, or maybe you've done it once. It's been a long time. So let's just walk through what the typical eviction process looks like. First of all, you need to serve a proper notice on the tenant. How is service done of this notice? Well, it can either be by hand delivery, by post. So if you knock on the door and the tenant opens the door, you can hand deliver that to them. It can be done by posting it on the door, or it can be done by mailing. Now remember, if you're going to mail a 3-day notice, which is the normal notice for non-payment of rent evictions, you have to add 5 additional calendar days to it, not to end on a weekend or a holiday. So if you're mailing it, you're gonna have to add some extra time. Our best practice for a 3-day notice is to go ahead and post it on the door or hand deliver it to the tenant and keep a copy of that. We'll get into some of the other types of notices, like the CARES Act notice, which is a 30-day notice, and I'll get into the CARES Act shortly. That 3-day notice essentially becomes a 30-day notice if your property and your tenant falls under the CARES Act, which we'll discuss shortly. There are some other types of notices, such as if there's a breach of lease or lease violation, such as, for example, if they have pets in the property and they're not supposed to have pets, and these pets are not service animals or emotional support animals, or they have unauthorized occupants that you can prove in the property, or they have too many vehicles that aren't supposed to be there. Any type of lease violation, you can give a 7-day notice to cure for, so that's another type of notice. Or if you're going to terminate a month-to-month tenancy, you can give, in Broward or Palm Beach, you can give that 15-day notice of termination of month-to-month tenancy. In Miami-Dade, in the city of Miami, Miami Beach, for example, you have to give a 30-day notice. That's a specific municipal statute that those cities have, okay? But in Broward and Palm Beach, it's a 15-day notice. Let me give you an example real quick of month-to-month tenancy, so we're on the same page when I talk about this. What is a month-to-month tenancy? Well, a month-to-month tenancy is generally created either by a lease, a 12-month lease that has expired, and you continue to collect rent. For example, the 13th month, if the tenant doesn't move and they give you the rent, then you've created a month-to-month tenancy, for example. Or it can just be a verbal month-to-month tenancy from the very beginning with no lease. They pay you a month of rent, they move in, you accept it, you've just created a month-to-month tenancy. So therefore, you can terminate that month-to-month tenancy by giving that 15-day notice, a minimum of 15 days prior to the end of the next, or prior to the beginning of the next monthly rental period. So if rent is due on the 1st of the month, today is September 3rd, and you want to terminate a month-to-month tenancy for September, you would give this quote-unquote 15-day notice, for example, today, but you would have to give them till September 30th to vacate. Remember, it's not 15 days from the day you serve it, it's a minimum of 15 days from the beginning of the next monthly rental period for that you're giving them. So essentially, you give them that 15-day notice today, they must be out September 30th. You could give it to them on the 10th of September, you can give it to them on the 12th, or up to the 15th. The 15th would be the last day that you can give them for September to terminate a month-to-month tenancy. And we'll get into month-to-month tenancies and holdovers and evictions such as those, because those are going to be probably much smoother and easier than a non-payment of rent eviction, and I'll explain why. But let me get back to where we're at. The eviction process, you've served whatever type of notice that you need to serve. The notice expires. Then we can go ahead and file the eviction. We file our evictions electronically for our clients. It means the clerk immediately receives that eviction complaint along with a summons. The clerk then would issue that actual summons and email us back. Normally that takes a day or two in most counties. Miami-Dade, we're having to mail summons in. It's taking a long time in Miami-Dade, but in Broward and Palm Beach and other counties, we get those summons issued electronically. Those are normally done within 1 to 2 business days. We get that summons, we send it on to our process server. The process server goes out to the property. They knock on the door. If the tenant does answer, or someone who's 15 years or older that resides at the property, we can then serve them with substitute service or personal service, and then they're served at that point. If they don't answer the door, then the process server needs to wait a minimum of 6 hours and then come back to the property, knock on the door again. If the tenant still does not open the door, then they can post that complaint and summons on the door and get them served. And then that begins the 5-day business day period that the tenant has to file a response to the complaint. So they can file an answer, affirmative defenses, motion to dismiss, any type of responsive pleading. That's what we call a contested eviction. But if they don't contest the eviction, then we file a motion for clerk's default with the final judgments. The clerk then enters a clerk's default, and then typically a judge would then enter the final judgment. And then if the tenant's still in the property, you would then need to get a writ of possession issued by the clerk. Writs of possession are $90. In Florida, in most counties, in Miami-Dade, they're $115. We would supply a sheriff's information sheet. The clerk then issues the writ of possession. They send that on to the sheriff. The sheriff then goes out, knocks on the door, and posts a 24-hour notice to vacate on the door. And then the sheriff calls you, your agent, your realtor, whoever's handling this, to schedule a time to meet at the property to then change the locks, and you can then remove all the belongings out to the property line of the tenant. And whatever happens to that property happens. You're insulated from liability at that point once you have that writ of possession, okay? So those are the basics of the eviction process. I know some questions I get is, well, typically, how long does this take? Well, prior to all these moratoriums, so if you asked me this question back in January or February, I would tell you that in most counties, and let's say in Broward and Palm Beach, for example, we can get a final judgment for an uncontested eviction in about 3 weeks, sometimes maybe up to 4 weeks. And in Palm Beach, it's about an extra week for the sheriff. And in Broward, it's about a week and a half, sometimes up to 2 weeks for the sheriff to do the writ of possession process. So you're talking anywhere about 3 to 5 weeks for an uncontested eviction. If it's contested and the tenant fights it, a number of different things can happen. A judge could order a hearing to determine rent. A judge could order a final hearing or a trial on the matter. A judge could order a mediation to see if the parties can come together to settle the case. Different things can happen, but I would generally say that you want to add an extra 2 to 3 weeks on top of the uncontested eviction timeframe. So for a contested eviction, generally in Miami-Dade or Broward or Palm Beach, I'd say about 6 to 7 weeks to get final judgment and then a writ of possession, okay? So those are the general timeframes traditionally for evictions. Now we're in a whole new world now. It's the wild, wild west, as I like to say, for eviction land. Things have changed so much. So now let's get into what some of the changes are that we need to go through.
Okay,
Ryan, if we can get the next slide.
Here. Yeah, give me just 1 second.
Sure.
Answer a couple of quick questions here at the same time. Okay. There you go. Okay, so
there have been many changes that I've been alluding to here on the federal, state, and local level the last few months, since March of this year. There's been the Federal CARES Act that was passed by the federal government. That was that $3 trillion bill that Congress passed and President Trump signed. Included in that was some eviction moratorium language that is technically now since expired, but it still has an effect on certain types of evictions, which I'll talk to you about. There's been the governor's eviction moratorium with 5 different extensions that have been provided for, but those extensions, at least the last extension, limited the effect of that moratorium. I'll get into that as well. The Supreme Court had some restrictions on writs and in-person court hearings, which courts are still following. Some of that we're having, when there's hearings, there's a lot of Zoom hearings, not in person. We'll talk about that briefly. We'll get into some of the sheriffs, county clerks, and courts that have different interpretations and procedures that are different between counties and judges, which is really, that's where we get into the system where we have 67 different counties in Florida. Within each county, there's multiple different judges. There's sheriff's offices, there's county clerks. So there's a lot of different interpretations, different ways that evictions are processed and pushed forward here. So there's no one set answer that I can give you for a lot of these things, but we'll get into that more shortly. And then most recently, the thing that's really scrambled the eviction world here is on Monday, the CDC, through the administration, the Trump's administration, ordered a moratorium on certain types of evictions with certain types of defenses that I will also get into here. This is very new, a new order. It's still being interpreted. It's going to take some time for us to really have solid answers based on how courts are going to treat these things, if there's going to be more guidance provided by the CDC or the administration. But I'll give you sort of my gut reactions and what best practices are as we move forward here. Okay, so let's talk about the Federal CARES Act first. What is the Federal CARES Act? I talked to you about this was the $3 trillion bill with aid for PPP loans and all the bailouts for airlines and big companies, and that had a lot of different aspects to it. But one of the aspects was at least a partial eviction moratorium that went into effect March 27th and expired July 26th. It has expired, but it has been brought up. Again, I don't know if you've been following the politics in Washington, but the Trump administration and Congress, especially Nancy Pelosi, they're butting heads. They're not able to come together on new legislation to extend the CARES Act provisions. So therefore, this is technically expired, which is why the president came and unilaterally, through the CDC, had this most recent order on Monday, because the CARES Act did expire and there's been no legislation to extend it. Could this CARES Act or something close to it be extended separately? It could be, but right now it's not. What is the CARES Act, though? It was a 120-day moratorium through July 26th on all non-payment evictions for 3 different categories of tenancies or properties. That included multifamily properties of 5 or more units that were receiving mortgage deferment assistance, properties that have a federally backed mortgage on them. So, for example, if your property has a federally backed mortgage on it, and how do you know if it does? Well, you would need to contact your lender or servicer and ask them, say, is my mortgage a federally backed mortgage? So you'll find out. If the answer is yes, then you would fall under the CARES Act. The third aspect of this, or third category, are those that have tenants receiving federal subsidies or Section 8 tenancies. If you fall into any of those 3 categories, and this is regarding non-payment of rent through the end of July, essentially, or through July 26th, if there's any rent that's due through July 26th, up until July 26th or through it, then you would have to serve a 30-day notice of non-payment on your tenant, okay? So again, I just want to make this clear. Although the CARES Act has expired, meaning moving forward for rent starting August 1st, you do not, especially if you have a federally backed mortgage or you have a Section 8 tenant, you do not need to serve that 30-day notice, okay? But if it's, so for example, if your tenant fell behind in August, but they were not behind on rent for July or June or May or April, then great. You do not need to serve a 30-day notice. But if your tenant fell behind, let's say in June, hasn't paid you June, July, August, and now September, and you have a federally backed mortgage, then you need to be serving them a 30-day notice, okay? So bear that in mind. Or if you have a Section 8 tenant and the Section 8 tenant is behind on, let's say, June, July, August, and September rent, you need to serve a 30-day notice, because part of the rent that's due and owing what came due prior to the July 26th end date of the CARES Act. Okay, so hopefully that makes sense for you folks. One other thing about the CARES Act is it carves out other types of evictions. It does not apply to termination of month-to-month tenancy, holdover tenants, breaches of lease, or commercial tenancies. It's only for residential non-payment that fall within those 3 categories. Okay, let's talk about the new CDC on the federal level, the new CDC agency order that came about September 1st and was signed. It's going into effect tomorrow once it's published in the registry, the federal registry. So this takes effect tomorrow. What is this new CDC guidance and order moratorium? Well, it's a moratorium in place through December 31st, 2020 for tenants that are covered under these protections. What are the protections? Well, it provides protections for tenants experiencing COVID-related hardships and who provide a specific hardship affidavit to the court or to the landlord, either prior to filing the eviction or during the time of the eviction. It only applies to residential tenants, and it likely only applies to evictions regarding non-payment of rent. The guidance is still new. We don't know how courts are going to interpret it, but based on our reading of this order, it likely still allows for evictions for termination of month-to-month tenancy, holdover, lease violations, etc. Okay, so it's likely only regarding evictions for non-payment of rent. There are some specific carve-outs for evictions due to contractual breaches, destruction of property, criminal activity, health and safety of others, code violations, etc. So, again, this is going to be, this guidance appears to be for residential non-payment of rent tenancies and tenants who provide their landlords or the court a hardship affidavit. That hardship affidavit is specifically laid out in this order, and it has 5 different categories of this affidavit, which we'll get to here with the next slide. So this is the terms of the affidavit that the tenant is attesting to. And I'll read through these and walk you through these. Number 1, the individual has used best efforts to obtain all available government assistance for rent or housing. The individual either expects to earn no more than $99,000 in annual income for calendar year 2020, or no more than $198,000 if filing a joint tax return, was not required to report any income in 2019 to the U.S. Internal Revenue Service, so to the IRS, or received an economic impact payment or stimulus check a few months back pursuant to Section 2201 of the CARES Act. So those are their stimulus payments. So if any of those 3 things are true, then they would fall under this category 2. So that would be true. The third category that they're attesting to is that the individual is unable to pay the full rent or make a full housing payment due to substantial loss of household income, loss of compensable hours of work or wages, a layoff, or extraordinary out-of-pocket medical expenses. Number 4, the individual is using best efforts to make timely partial payments that are as close to full payment as the individual's circumstances may permit, taking into account other non-discretionary expenses. And number 5, the eviction would likely render the individual homeless or force the individual to move into and live in close quarters in a new congregate or shared living setting because the individual has no other available housing options. So these are the things that are included in this affidavit, that if an affidavit is provided to the landlord prior to an eviction, they should not file an eviction. So if you get something close to this, or you get this specific affidavit, no matter what, I don't care if you have a federally backed property, a mortgage, you don't have a mortgage, you have Section 8, you don't have Section 8, it doesn't matter. As long as it's a residential non-payment of rent issue, you should not move forward with an eviction for non-payment of rent if you get this type of affidavit. If we file the eviction and this affidavit is presented at any time during the eviction, that is most likely going to stop and stay the eviction through the end of the year, through December 31st, 2020, when this expires, okay? So this is a kind of, you get this affidavit or something close to it, it's a timeout. Don't pass go, don't collect $200, don't collect, and I mean that figuratively. You can still continue to collect rent if they give you the rent, but you should not be moving forward with the eviction. And if we are handling an eviction for you and you get this type of affidavit, you need to let us know immediately, and we therefore would need to essentially likely stop the eviction at that point, okay? There are serious penalties for this in the hundreds of thousands of dollars for a violation of this, so you don't want to be playing around with this, okay? This is an order that has teeth to it, okay? So that's the CDC agency order. So let's move on here.
And real quick, Jaron, I just want to also remind you guys, I'm still getting questions in the chat. I'm not going to answer questions in the chat because it's too difficult that the questions get lost in the chat. put your questions, please, in the Q&A for us, okay? We'll get to everybody's questions, but I just need you guys to put your questions in the Q&A.
Great. And I've got some more content for you, so maybe hold off on your Q&A till we get towards the end. And once I'm done here, you can type all the questions you want, because I might be answering your questions here. I'm going to do a summary of everything and give you sort of a bottom line, and that might answer a lot of your questions. But let's move on to the state level. The governor's non-payment of rent eviction moratorium. This was originally issued April 2nd. It has been extended 5 times through October 1st. The amended and updated restrictions apply to residential non-payment of rent evictions where the tenant has been adversely affected by the COVID emergency. This includes loss of employment, diminished wages or business income, or other monetary loss realized during the emergency that directly impacts their ability to pay. And this has restrictions on the final action of the eviction for cases that fall under these protections. What is the final action? Well, that could either be the final judgment or it could just be the writ of possession. It depends how a judge interprets that. Okay, so, and we'll move on here to the next slide, and we'll talk about what is not restricted under this governor's moratorium for non-payment of rent evictions. Well, you can serve notices on the tenant, including a 3-day or a 30-day notice. 30-day would be for the CARES Act. If your property fell under the CARES Act for rent that was due prior to July 26, and you either have a Section 8 tenant or a federally backed mortgage, or you have a multifamily 5 or more units that is still under mortgage deferment, you must give a 30-day notice. The filing of evictions for non-payment, technically, we can file these as long as you have not received this affidavit under the CDC moratorium. We can move forward with filing, likely move forward with the filing of the eviction. And we might very well be able to get final judgments against tenants who do not contest the case or who don't meet the protection standards of this executive order or the CDC order that allows for them to file that affidavit. So if all of those things are true, a judge may move your case forward and may grant a final judgment and may order the sheriff to execute the writ of possession. There are no guarantees of that, though, and I'll get to the bottom line here in a few minutes, but I'm just pointing this out. The issuance of the writ of possession can likely happen unless the judge rules that the case falls under these protection standards where there is a COVID hardship that based upon the judge's determination, okay? So those are the carve-outs that are not covered under this. Some other types of cases not included in the CARES Act and the governor's moratorium and likely the CDC moratorium. Residential month-to-month terminations, we talked about that 15-day notice. If you have a month-to-month tenant, you likely want to go ahead and just terminate their month-to-month tenancy. Give them that 15-day notice and tell them to be out September 30th, and then we could file the eviction October 1st. Because these other protections are generally across the board are for non-payment of rent evictions. So don't bring up non-payment if you don't have to. I understand maybe they're not paying your rent, but let's go a different route that's an easier route, which would be month-to-month termination. Or residential holdover evictions. What is a holdover eviction? Well, that's if you have a lease, let's say you have a 12-month lease, and your lease is expiring on September 30th. My recommendation to you is don't go for non-payment of rent eviction. Just don't renew their lease. If you want to, if either your lease requires it, or let's say you're using a Florida Realtor's lease that does not require a notice of non-renewal, you can go ahead and give them a notice anyways, just to make sure you're dotting your I's and crossing your T's saying, your lease is expiring September 30th. We are not renewing it. Please vacate by September 30th or you'll be subject to eviction. Something like that. There's no specific statutory notice you have to serve, but always good to serve a notice that says you're not renewing the lease. That is a holdover eviction. So meaning if they're holding over, the lease is expired, they haven't created a month-to-month tenancy, you've not accepted rent after the lease expired, then you can just move forward with a holdover eviction. Also, the other types of evictions are non-rent default breaches of lease. We talked about that, like having pets in the property when they shouldn't, having unauthorized occupants that you can prove that are in the property, or let's say they're damaging the property, or they're supposed to maintain the property in some way and they're being destructive to the property, or having criminal acts on the property. These are 7-day notices that can be served on them. They may be curable, they may not be curable, but we can do that as long as you can gather the necessary evidence to prove you have photographic evidence or videos that you can prove that the tenants are in violation of their lease, and we can move those types of cases forward because they are non-rent default breaches of the tenancy, okay? And any type of commercial eviction does not fall under any of these moratoriums as well, okay? So those are things that are essentially carve-outs. Most of these evictions, we have not been having issues with getting final judgments and writs of possession for those different types of cases in the different courts. The new CDC rule that came out on Monday, we will just have to see how different judges interpret that rule. Again, our opinion is that the CDC guidance does not affect those other types of cases that I just walked you through. The termination of month-to-month tenancy, the holdover for leases that have expired and have not turned month-to-month, the breach of lease, or commercial evictions. Based on our reading of the CDC order and guidance, we don't believe that it covers those types of evictions, but we will have to see. We're not guaranteeing any results here. Now, bear in mind that there have also been some other lingering issues slowing cases down, different county court and clerk issues and sheriff issues. For example, I mentioned this earlier, summonses in some counties are very slow to issue. For example, if you have a property in Miami-Dade, they don't issue those summonses electronically, which are very quick and efficient. In other counties across Florida, like Palm Beach and Broward, we have to mail in the summonses, and sometimes it's taking a week, 2 weeks or more to get those summonses back. So it's been very slow. Some sheriffs are not executing writs unless it has very specific language in the final judgment that a judge says that the tenant is not protected by these other protections, such as the CARES Act or the Governor's Moratorium, or now the CDC Act, or order rather, and some sheriffs are not serving some types of writs of possession. So there's been some real, I'll just say, some confusion depending on the county, depending on the judge, depending on the clerk and the court. And again, judges are interpreting these orders differently and not always setting hearings expeditiously. When there are hearings, generally these are Zoom hearings, it's not bad. It's actually good. It's fairly efficient. But again, a lot of times what they would do, certain judges would, in the past, they would pack 10 or 20 cases and parties into a court at one time and move those cases forward expeditiously. Now, with the Zoom hearings, a lot of times they're setting these cases out to have a Zoom hearing one at a time, which is kind of slowing down the system a bit. And then, what is some of the good news? The good news is up to this point, up to Monday, where the CDC issued this new order, things were picking up speed. Things were moving fairly quicker than they had been in the prior weeks and months. And courts were reopening, clerks were reopening, summonses were being issued, final judgments in many cases were being issued, and we were getting some good results for our clients. Then the CDC order came in, it threw a curveball into the works here. I don't know 100%. Again, I have to keep reiterating this. I can't give definitive 100% advice that if you file an eviction for non-payment of rent, even if you dotted your I's and crossed your T's, that those cases are going to move forward expeditiously to a final judgment in front of a judge. I can tell you that it's likely that we can file these cases for non-payment, and if the tenant does not contest the case, so they don't file an answer, they do not provide a COVID hardship defense, they do not provide that affidavit as laid out by the CDC and the CDC's order, that there's a good chance that you might get a final judgment from a judge. Even if they do contest the case, a non-payment of rent case, there's also other alternatives, such as settling with a stipulation agreement. That's a court-ordered agreement that you can work out with a tenant separately outside of court, and we can draft for you and get the tenant to sign it. Or if we go to a mediation, or even in court if a hearing's set and we're able to work these issues out, whereby maybe they agree to just move out on a certain date in the future, let's say 2 weeks from now or a month from now, and you give them the time to move out, we can work out stipulation agreements, and as long as they comply, that's wonderful, and they move out, that's good. Then you get possession back. And if they don't, in most cases, we're able to file an affidavit of noncompliance and get an expedited final judgment from the court if you get that stipulation agreement. So there's a lot of different things that may happen after an eviction case is filed, especially for non-payment of rent. But the bottom line is, as long as you're complying with the terms of these different rules, then, and as long as you want to move forward with a non-payment of rent eviction case, we can do that. We can file the cases, but we're not guaranteeing any results based on different judges, different courts, etc. So you just need to be prepared that if you are filing a non-payment of rent eviction case, your case could get stalled for a period of time or an extended period of time, at least through December 31st, if a COVID-related hardship defense is raised, and or especially if an affidavit pursuant to the CDC order is provided to the court or to you as the landlord at any point during the eviction case, okay? Other than that, though, that's a huge caveat, I understand, but other than that, up to now, cases were moving forward fairly quickly, and they were getting pushed forward, but in most courts and with most judges, okay? So we'll get into the Q&A, and I'll let Ryan take over here in just a second, but just bear in mind that if you do have a specific, quick question, if you say, hey, Jaron, I've got a tenant that's, I'm Section 8, and that's Section 8, and I know I need to do a 30-day notice, but you have a question about that, and we're not able to answer this, you could pop me a quick email. There's my email address right there, jaron@kellygrantlaw.com. Kelly with an EY. Don't miss that E before the Y. A lot of people get bounce back emails. Or you can call our office and speak to any one of our team members. If you have a specific question and need help with an eviction, we're always happy to help folks and guide them in the right direction. One final thing before we get into the Q&A, we get a lot of questions about, well, Jaron, how do we file an eviction with you, or how do we move forward? Well, again, you can call us and we can guide you, or you can go right on our website. And if you're certain that you're doing things right and you want to move forward, you click Start a New Eviction right on our website, and you can fill out that online intake form in just a few minutes and upload all your documents. And then one last thing, the website has a lot of different resources there, videos, articles, has specific information about the CDC, Governor's Moratorium, all of that is right there, and you can get started. Our pricing for evictions is also on the Start a New Eviction page on our website. We charge $195 for the attorney fee plus the filing fees. Generally for a one-tenant eviction, that's going to be $435 with a $195 attorney fee plus the filing and service fees. Okay, so Ryan, I'll let you take over from here.
All right, so we've got a few questions here. Okay, so Jack Seals was asking, he's got a real-world question for you. Lease has a no repairs by tenant unless authorized by property manager clause. Last week, we got a call that the AC was not working. The AC guy went out, found the system was overcharged. The tenant either charged or had something out who overcharged the AC. He would like them to pay the bill. Is there a way, how would you approach this in this kind of situation?
Well, this would be a breach of lease, so a violation of the lease, and you would need to give a 7-day notice to cure to them. That 7-day notice would need to state three things, essentially. One is how they're violating the lease provision, what that lease provision is, so lay it out, Section 7 of the lease and what it says, how they violated it, and what they need to do to cure it. Now, I can tell you the next part of this equation is, well, what happens if they don't pay? So let's say it has it says that they're supposed to pay for this and it was $100 and they don't pay the $100. Are you going to bring them to eviction for $100? I don't necessarily think that's probably a wise move. I don't know that a judge is going to evict someone over $100, and the judge would probably say, well, take it out of their security deposit. You can fight over it at the end of the security deposit. So if it's something that's a serious violation, so again, if they have pit bulls on the property and they're not service animals or emotional support animals, and you have proof of that, you have photos and videos, and these pit bulls are dangerous, and you want to give a 7-day notice to cure, and they don't remove the animals, and after the 7-day notice to cure expires, you can go back in and take more videos and photos showing they're still in the property. That's an eviction that we can bring, and that's not covered by any of these different moratoriums, okay? So hopefully that answers your question.
Yeah. Now, we have another question. Is that asking about the same rules for evictions go for foreclosures also. So basically, if a borrower defaulted in January 2020, do they get a pass if they defaulted before COVID?
So I'm just going to answer this very quickly, and I'm not going to get I'm not a necessarily foreclosure attorney. We do HOA foreclosures. We do some private money foreclosures as well, but I just want to stay on topic here. The bottom line is no, foreclosure moratoriums are different than these eviction moratoriums. So everything we're talking about here today is for eviction moratoriums. Okay, so that's a separate topic for another webinar another time. Yep.
There you go. Have a renter whose lease expires on September 17th, 2020. Given them notice 1 month ago that I do not intend to renew, but he's told me that he's not leaving the property. Can he evict that tenant?
Yes. So Colin, yes, you can. We can file the eviction for the holdover. I'm fairly certain that the CDC order does not cover this, and I know the CARES Act order doesn't. The governor's moratorium does not cover this. So you should be in good shape with a holdover eviction. We can assist you with that. If they're still there on September 17th or 18th, you can go ahead and we can file an eviction for you on that and get that moving. And we've been successful up to this point in getting final judgments for those types of cases.
Okay. And also, if there isn't a lease in place, can they still evict during this executive order, I guess, if they're renting month to month? Correct.
So that's right, Ryan. So if they're month to month, then what I discussed, kind of early on through this is that you would, if it's Broward or Palm Beach County, you would give them that 15-day notice. For example, if rent's due on the 1st of the month and you go serve them a 15-day notice today or tomorrow or on the 10th or up to the 15th of September, you can serve them that 15-day notice, but you would have to give them until September 30th, and then we can file the eviction on October 1st. So, yeah, and you should be good. You're definitely not covered by the CARES Act. You're not covered by the governor's moratorium. And you're likely not covered by the CDC moratorium as well.
And you were talking about it's proving that they are emotional support animals, obviously, because they're asking, officially, but common sense would tell me, wouldn't there be a documentation that they would have that they can provide to their landlord that says this dog is a registered emotional support animal, right?
So I'll cover this very quickly. This could be, actually our attorney here gives an hour-long seminar on this. So I don't want to spend too much time on this, but I'll give you the super 40,000 foot high level is that they are supposed to provide a letter from a doctor or another healthcare professional, essentially tying their disability to the need for an emotional support animal or service animal. And then if they do that, then you do need to honor that, and they are not a pet at that point. Sometimes there's gray area things, like there's psychologists that are online in California, and they pay $50 to get some letter. They've never seen the dog, never had a consultation with them. Those are things that get into the gray areas. My best advice is that if you are getting documentation about a service animal or an emotional support animal, take a hands-off approach, because if you violate the Fair Housing Rule and Act, then they could go ahead and file a complaint against you, and that can be very stressful, daunting, expensive if you need to hire an attorney to fight against that. So best to stay away from fair housing fights when they provide some reasonable documentation of an emotional support animal or service animal. Bona fide, depending on how you pronounce it, a bona fide tenant, which if they have a lease and the lease has a reasonable amount of rent, so it's of or close to market value, and it's not it's an arm's length lease. So for example, if the prior owner was Susie Smith and her daughter Joni Smith, she rents the whole 4-bedroom house out for $400 a month for the next 9 months, that's not a bona fide lease. And you can bring that to court, and a judge is likely going to say that's not a bona fide lease. It's neither arm's length, meaning it's a family member, nor is it a reasonable rental amount. So it's just a proxy or a fake lease, essentially. But if there's a bona fide lease, then you need to honor the lease, whether it was written at the time that the foreclosure started or prior to it, as long as it was essentially written prior to the property, prior to the certificate of title being issued. Then it would be a bona fide lease, because only upon the certificate of title being issued is the title to the property actually technically transferred at that point. Okay. So does that hopefully that answers that question. But back to the original question is, what is the process for it? It is different. It's not a county court eviction. We handle these types of evictions. What they are is we serve a notice to vacate on them. Generally, we give a 30-day notice. That's Florida calls for a 30-day notice of termination if there is a tenancy, if it's month to month for post foreclosure properties. So we serve a 30-day notice. We ask them if they have a copy of the lease to send it to us. That's all part of that notice that we give. Most of the time they don't give us any type of lease. Then we go ahead and we file a motion for to order the writ of possession. We're doing that in the foreclosure court. So we're piggybacking off of the foreclosure. We're reopening the foreclosure case and we're filing that motion to order the writ of possession. And then we get the judge to order the writ. And then that's when you get the sheriff to come out and remove any occupants. And again, the only caveat to that is if they have a bona fide lease, then you're going to have to honor it if they come up with one. Yep.
Right. Buyers beware, guys. Buyers beware.
Correct.
Section 8 tenant in Broward has not paid her portion of the rent for several months. However, Section 8 is paying their portion. No government-backed mortgages on this house. Can I file an eviction?
Well, again, what you're going to have to do is it's been several months, so obviously they fall under that CARES Act 30-day notice. So you need to go ahead and serve the 30-day notice for their portion of rent that they have not paid. And then once that expires, then technically we could likely move forward with an eviction for non-payment of rent. But remember, the other caveats there is that if they provide for a COVID-related hardship defense, that would fall under the governor's moratorium. If they serve you with that affidavit or anytime during the court process, then it's likely going to stall your eviction for several months, at least through the end of the year. And remember one other thing, for Section 8 tenants, most of the time they will get free legal aid representation. So you have to be very careful of that. I would say if your lease is going to end in the next maybe 30 or 60 days, let's say hypothetically if it's going to end at the end of September or October, maybe even end of November, just don't renew them, and then we can file an eviction for a holdover tenancy. It's probably going to be the better way to go, especially because your Section 8 rent is probably a relatively small portion of the larger rent. So that would probably be my advice, because if you can avoid doing an eviction for non-payment of rent, like again, your lease is expiring soon or they're month to month, then I would go ahead and terminate those tenancies or not renew it and file an eviction for those other reasons.
Right. Now, I thought maybe you had answered this before, and this might be too big of a question to really get into it, so Ron can follow up with you. But does the CARES Act give landlords any rights?
I'm not sure exactly how to answer that. I would just say it's mostly focused on tenant rights because it is providing tenant protections for non-payment of rent issues and what landlords need to do in order to comply with the CARES Act. So I guess my short answer to that is, for the most part, no, it is not doing that. Now, I'll say one other thing, that the CARES Act did provide funding that has slowly trickled its way down from the federal government to the state government, and the governor has dispersed that to different municipalities. And you can call your local municipality. I don't know exactly, every municipality is different. You could call your county, maybe start there, Broward County or Palm Beach, or go to different cities and see if they have funding for landlords. So for example, if your tenant's fallen behind on their rent for 3 or 4 months, you could see what programs are out there. There are, I believe Florida had about $250 million that was dispersed across the state of Florida to help landlords out and tenants out. But you might have to do the proactive work to go and see what programs are available, because your tenant may not. Your tenant may think that they're completely protected and they don't need to do that hard work.
Yeah. So. Broward and not acted upon before the moratorium was issued. The lease expired in April, so it's a holdover tenant.
You can consult with us. We could do a paid consult with you, AL. We'd have to look at the docket. We'd have to figure out where we need to go with this and talk about that. If you want to reach out to me, we could set up a paid consult. You've already filed your eviction, so we could discuss that and talk about next steps and some actions. We have been successful in resurrecting old cases, and we have been successful in most situations with getting renewed final judgments or orders to reissue the writ or get an alias writ. So there's different ways to go about doing that.
All right. Let's see. On a month-to-month tenancy, if you decide not to renew the lease and give a 15-day notice in Broward County, can you still go after unpaid rent once the tenant leaves?
You can always sue for damages, and that's up to you. Again, I'll say the same thing. I don't recommend spending a lot of time on that, though. You're probably not going to, you can't squeeze blood out of a stone, as they say. So.
Okay. Do you handle mobile home review of documents, work with clients that have mobile homes they rent out?
If you're talking about a regular lease of a mobile home, so you own the mobile home and you want to lease the mobile home out to a tenant, then that's going to be a traditional lease. And yes, we do landlord-friendly leases all the time. You can do a lease right on our website. If this is a leasing of land to a mobile home, no, we don't do that. That's very different. If you own the land and you're trying to get someone else's mobile home on there, we don't do lot leases. So there's specialty law firms that do that.
Okay. Karen, on that,
Yeah. So, again, a couple things here. First of all, it's going to be easier and you're more likely to get a more expedited eviction and likely not going to face these different varieties of moratoriums if you can either terminate a month-to-month tenancy, not renew a lease if it's coming up here in the next month or two, or if you have a valid reason to evict them for a lease violation that you can prove to a judge, and a judge will be willing to evict them because it's a serious lease violation. So if you can do one of those three methods, that's always going to be your best practice. And most likely you're not going to have issues with judges and courts with pushing those cases forward, because most of these moratoriums do not deal with that, okay, those different types of cases. Now, if let's say your lease still has 9 months left on it, and the tenant hasn't been paying you for 3 months, well, then you are likely going to have to consider going through an eviction for non-payment of rent. You need to make sure that if some of the past due rent fell under the CARES Act, or it was a Section 8 tenant, or one of those different areas that we talked about under the CARES Act, you would have to give a 30-day notice. If it is not a federally backed mortgage, or you don't have a Section 8 tenant, then you can go ahead and serve a 3-day notice, and then we can likely begin the eviction process as long as you have not received an affidavit or something substantially similar to it, implying that they have COVID hardships. If they do have COVID hardships, and they put that in writing or especially an affidavit similar to what I walked you through on that CDC affidavit, then you're going to probably have to wait till December 30th, or actually January 1st, assuming that that moratorium is not extended, the CDC moratorium, and then begin the eviction at that time. But if you have not heard anything from the tenant, they've gone silent on you, they haven't alleged COVID hardships, then you can likely utilize our services and we can begin the eviction process. And let's hope that we can push the case forward in an expedited manner, and hopefully we don't have problems with judges on that.